Hey, this is Kent Jones with Jones and Associates, BC in Cleveland, Tennessee. We cover Bradley County, Hamilton County, Marion County, McMinn County, Polk County, and we go outside of those areas on an as-needed basis. I wanted to talk to you about part 2 of the series on workers' compensation law in the state of Tennessee for employers. If you are covered by workers' compensation law in the state of Tennessee as an employer, the next question is, what do you do when an employee has either an injury by accident or an occupational disease within the scope of employment? If you're not a direct witness or a supervisor, his or her supervisor is not the direct witness, then the employee by law has 30 days to provide you with written notice of the accident. Written notice is not a great defense. The Bureau of Workers' Compensation construes it liberally. Oral notice has been allowed on a multitude of occasions, going back to the court system and as it came up through the Department of Labor to the Bureau of Workers' Compensation. Your first obligation when you get a notice of an injury by accident or occupational disease is to provide a panel of 3 physicians for the employee to choose from for authorized medical treatment. The medical bills from that particular physician are to go to your carrier, who also should have been notified by you. The carrier probably has their own panels which they'll give you to present. The medical bills are not to go to the employee. During the scope of treatment, a number of things can occur. The first thing that can occur is the doctor will give your employee medical restrictions, and you'll take a look at these and make a decision as to whether or not the employee can work his or her job that they had prior to the accident. If they can't, then there are a couple possibilities. The first one typically is you may have a light duty program or a light duty job that you can put the employee in and have them work that. And so long as they are working at the same wages that they were receiving prior to the accident or incident, then you won't owe them temporary total disability. And now I'm going to backstep just one bit. If the employee is able to go back to work, but at a job in which you're paying him or her less wages, then you're going to be probably confronted with temporary partial disability. And what that is it's a situation where you take the average weekly wage of the worker, and we'll cover that in section 3, and find out what he or she is making now, and then you owe the employee a biweekly check of 66 2/3% of the difference between the two. Average weekly wage is usually determined. I'll go ahead and go into it a little bit. Average weekly wage is usually determined by the last 52 weeks the employee has worked, and you go week by week and show their wages, and then add them all together, divide by 52. That's their average weekly wage. If less weeks, you have an employee that has not worked 52 weeks for your company, then just use that amount of weeks. Let's say it's 40. Then you take 40 weeks of wages, add them together, get a total, and divide by 40, and there's your average weekly wage. The situation becomes a little bit a little bit more complicated if you go down to a level. Usually it's been around 13 weeks or below. It varies, at some point around that point, you may be asked to give the Bureau of Workers' Compensation and a wage statement of what's called a comparable employee. And then you take that comparable employee's average weekly wage, and that is the average weekly wage that you're going to be working with. In the next segment, we're going to be talking about the different types of disability and some more items that follow that particular subject. Thanks. Hope you guys have a great weekend, and talk to you later. Go Vols!